Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right. We're back. We're back with the Truth Attack. Okay, so there's a lot I want to get to tonight, so let's just get right into this. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating and the shows and the information coming. So, if you enjoy the information, the lectures, the topics, the discussions, the revelations, the guests and hosts on the other shows of the network, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website, if you're not there now, listening online already, and get signed up as a monthly subscribing member, even if it's as little as $15, $20 a month. Every membership helps, and we do need your support to keep the network operating. And if you want to get fully informed on the unconstitutional enforcement of the federal income tax that's been perpetrated against the American people since basically 1950, or actually World War II, find your way over to taxfreedom.com and start reading. Because the Supreme Court has issued a more recent ruling just last year that restores the tax as an indirect tax and destroys the government's enforcement of it as a direct tax, which is what they've been doing unconstitutionally, well, for the last 75 years. Okay, we're going to get into that in just a bit, but first let's talk a little bit about current events. Seems like the two stories here are what I've been telling you for a while. Trump's economic recovery is really pretty good. GDP is at 3%. Domestic gross product increased 3%. Inflation is at 2.5%. Unemployment is low. Both stock markets, the NASDAQ and the Dow Jones, are at or near all-time highs. And the only thing preventing the economy from roaring back is Jay Powell and the Fed, who refused to lower interest rates, despite the fact that in 6 months Trump has dropped the inflation rate below the 2.5 Powell said he was waiting for, despite the fact that the economy is beginning to recover. He's still worried that tariffs will knock it out. It was never Trump's intention to use tariffs to raise money. It was his intention to use them as leverage to force other countries to enter into new trade agreements that are more favorable to the United States, which is exactly what he's done. So, they just announced a new trade agreement with the EU and with Japan, where those countries will be investing substantial sums of money in the United States while paying a small tariff to have access to the United States' market, while having no tariff imposed on the United States' sale of our products in those countries. So Trump is completely reversed. And the international trading system, and he's putting in place a system that bodes very favorably and very well for American businesses as foreign markets are being opened up for us to sell into and expand our production and sales. The other story, of course, is what I told you 9 years ago. The Russian nonsense from the Democratic Party was a Hillary Clinton initiated fraud in an attempt to essentially interfere with Trump's ability to administer to the government for his first 4 years of the term. The whole thing was a complete and total fraud. Obama was involved. Brennan, Comey, and Clapper took action and ordered the investigations, knowing the intelligence it was based on was completely false. So, I told you that 9 years ago, that it was all made up by the Democrats. Okay, so let's get back and talk more about the federal income tax, because as I said, just a year ago, the Supreme Court ruled in Moore et al. v. United States that income taxes are indirect taxes, not the non-apportioned direct tax under the 16th Amendment. They specifically ruled that the income tax is an indirect tax under Article 1, Section 8, Clause 1 of the Constitution. That means every single tax enforcement case for the last 55 years since 1980 has been a constitutional fraud perpetrated by the lower courts, who have been fining people up to $50,000 for asserting the constitutional truth, i.e., it's an indirect tax under Article 1, not an unlimited direct tax under the 16th Amendment. And in so doing, the Supreme Court refers repeatedly to the Bruchaber decision, the Bruchaber v. Union Pacific Railroad Company decision in 1960. That's 240 U.S. 1. And I've had a couple of people ask me to explain what they actually did in the Bruchaber decision. So that's what we're going to try and do this evening. I've got the Bruchaber decision here, and I'm going to kind of start with the conclusion and then go through the elements of the opinion to show how they support what's written up pretty succinctly in the conclusion. So, this is Bruchaber v. Union Pacific. This is the syllabus. Under proper averment, a stockholder's suit to restrain a corporation from voluntarily paying a tax charged to be unconstitutional is not violative of Revenue Statute 3224, and the district court has jurisdiction to entertain the action, citing Pollock v. Farmers Loan and Trust. In this case, that of a stockholder against a corporation to restrain the latter from voluntarily paying the income tax imposed by the Tariff Act of 1913. The defendant corporation notified the government of the pendency of the action, and the United States was heard as amicus curiae in support of the constitutionality of the act. Okay, the first thing here the syllabus says is that the suit was filed by a stockholder to restrain the corporation from voluntarily paying a tax. Now, what that means is Frank Bruchaber, the appellant, was a stockholder. He wasn't a taxpayer. If he'd been the taxpayer or the agent of a taxpayer, the case would have been dismissed under the Anti-Injunction Act. You can't interfere with the collection of the tax. But because he's a stockholder, he can sue his own corporation, the Union Pacific Railroad. And the reason why he sued his corporation is because they announced their intention to comply with the new income tax tariff law, which required his company, the Union Pacific Railroad, to make determinations and withhold tax from certain parties to whom payments were made. And the stockholder, Bruchaber, said, I don't want my corporation having to assume all of those expenses and the burdens and the liabilities that go with this duty. It's unconstitutional to force my company to spend money to do this. Okay, so the syllabus goes on. The 16th Amendment was obviously intended to simplify the situation and make clear the limitations on the taxing power of Congress, and not to create radical and destructive changes in our constitutional system. So right there, they're rejecting the contention that the 16th Amendment authorizes a new power to tax. They're saying here it doesn't do that. The 16th Amendment does not purport to confer power to levy income taxes in a generic sense, as that authority was already possessed. And by that, they mean they had the power to tax income since the series of decisions after and during the Civil War, where the court held that the taxes are a function of impost, duty, and excise taxation, indirect taxation under Article 1, Section 8, where income is not the object of the tax, nor is it the subject of taxation. Income is the yardstick that measures the amount of tax owed on the revenues derived from the earnings that are derived from activities and transactions subject to federal taxation by impost, duty, and excise under authority of Article 1, Section 8, Clause 1. So they can't tax you just because you earned money. The money has to have flowed from some activity subject to an impost on foreign activity and foreign persons, a duty on exported goods, or an excise on commodities, licenses, and corporations. Without the impost, duty, or excise, there is nothing to tax. And of course, in these decisions in the 1880s, citizens weren't subject to any income tax. It was only the corporate person, the licensed person, and the foreign person that were subject to the tax as an excise at that time. Okay, we go on. The income tax provisions of the Tariff Act of 1913 are not unconstitutional by reason of retroactive operation. The period covered not extending prior to the time when the amendment was operative, nor are those provisions unconstitutional under the due process provision of the Fifth Amendment, nor do they deny due process of law, nor equal protection of the law by reason of the classifications therein of things or persons subject to the tax. The provisions for collecting income at the source, and this is key, collecting income at the source, do not deny due process of law by reason of duties imposed upon corporations without compensation in connection with the payment of the tax by others. So right here, the court is telling Bruce Shaber that he can't interfere with the corporation's collection of the tax. It's not really a burden. It goes on. The uniformity of taxation required by the federal Constitution is geographical, citing Knowlton v. Moore. The Fifth Amendment is not a limitation upon the taxing power conferred upon Congress by the Constitution. Arguments as to the expediency of levying a tax, which is within the power of Congress to levy, are beyond judicial cognizance. When there are differences between the subjects that are taxed, Congress does not transcend the limit of its taxing power by taxing them differently. A want of due process of law does not arise from a want of wisdom in Congress in levying taxes, and thus give the courts power to overrule the action of Congress by declaring it to be unconstitutional. The facts which involve the construction of the 16th Amendment and other provisions of the Constitution of the United States and the constitutionality of the income tax provisions of the Tariff Act of October 9th, 1913 are stated in the opinion. So basically, the Supreme Court is telling Frank Shaber income taxes are constitutional. They've always been constitutional because they don't have to be intrinsically uniform, just geographically uniform. Okay? So let's look at what the opinion says, since the syllabus refers to the opinion. Now here, in the opinion, on the first page of the opinion, in the very first sentence, it starts, as a stockholder of the Union Pacific Railroad Company, the appellant filed his bill to enjoin the corporation from complying with the income tax provisions of the Tariff Act of October 3rd, 1913. Because of constitutional questions duly arising, the case is here on direct appeal from a decree sustaining a motion to dismiss because no ground for relief was stated. Okay, so again, in the first sentence, the court tells us that Bruce Shaber was not a taxpayer. He's a stockholder who filed the suit against his own corporation in order to stop them from complying with the income tax provisions. And now we're going to jump over to page 21 in the decision, where the court summarizes what they're looking at. Okay. This is on page 21. Without expressly stating all the other contentions, we summarize them to a degree adequate to enable us to typify and dispose of all of them. It goes on. The statute levies one tax called a normal tax on all incomes of up to $20,000, and from that amount up, by graduations, a progressively increasing tax. Okay, I think I hear the first commercial break coming up, so I'm going to get back to this and restate this part of the paragraph when we get back. This is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. We'll be back in 5 with more. Okay, this is Thomas Fried on the Liberty Works Radio Network, and I'm going to get right back into our discussion of the Brushaber case, where I've already pointed out that Frank Brushaber was not a taxpayer, nor did he represent a taxpayer. He was a stockholder of the Union Pacific Railroad who filed suit to enjoin the company from having to assume the administrative duties and the financial burdens of figuring out from whom do we withhold and how much, and does it get sent in properly. Brushaber objected to the government commanding his corporation to perform for the government instead of for the stockholders. And because he was suing his own company, after they announced their intention to comply with the new tariff law, the new act, the court took the case to settle the issues about the constitutionality of the tax. The government wasn't even involved. It filed an amicus curiae brief that, as I understand it, actually argued for the direct application of the income tax under the 16th Amendment, which the court rejects in Brushaber, stating that all of these averments aren't unconstitutional because the tax is not a direct tax. It's an indirect tax that only has to be geographically uniform, not intrinsically uniform. And it reaches only those parties that are liable for it. But here we go. And actually, I jumped into page 21 before the break, but I'm going to go back and read from page 20 because this is important too. We come then to ascertain the merits of the many contentions made in the light of the Constitution as it now stands, that is to say, including within its terms the provisions of the 16th Amendment as correctly interpreted. We first dispose of two propositions assailing the validity of the statute on the one hand because of its repugnancy to the Constitution in other respects, and especially because its enactment was not authorized by the 16th Amendment. The statute was enacted October 3rd, 1913, and provided for a general yearly income tax from December to December of each year. Exceptionally, however, it fixed the first period. Well, it goes on here to talk about how the tax was imposed on previous years. And so far as the limitation of the Constitution in other respects are concerned, the contention is not open, since in Stockdale v. Atlantic Insurance Company, in sustaining a provision in a prior income tax law which was assailed because of its retroactive character, it was said, the right of Congress to have imposed this tax by a new statute, although the measure of it was governed by the income of the past year, cannot be doubted. Much less can it be doubted that it could impose such a tax on the income of the current year, though part of that year had elapsed when the statute was passed. The joint resolution of July 4th, 1864, imposed a tax of 5% upon all income of the previous year, although one tax on it had already been paid, and no one doubted the validity of the tax or attempted to resist it. It goes on to page 21. The statute provides that the tax should not apply to enumerated organizations or corporations such as labor, agricultural or horticultural organizations, mutual savings banks, etc. And the argument is that as the amendment authorized a tax on incomes, quote unquote, from whatever source derived, by implication, it excluded the power to make these exemptions. But this is only a form of expressing the erroneous contention as to the meaning of the amendment, which we have already disposed of, i.e. it's indirect, not direct. And so far as this alleged illegality is based on other provisions of the Constitution, the contention is also not open, since it was expressly considered and disposed of in Flint v. Stone Tracy, 220 U.S. 107 at 173. Now, Flint v. Stone Tracy is the constitutional law from 1911 that defines the scope of the indirect taxing powers, laying out that imposts are taxes on foreign persons, on foreign activity, on foreign imports, and in certain foreign places, like possessions of the United States and in foreign countries under a tax treaty. It lays out that duties are taxes on exported goods, and we don't have duties in this country. That's why we have duty-free shops at the international terminals. And excises, Flint v. Stone Tracy ruled, are taxes imposed on the manufacture, consumption, and sale of commodities within the country, i.e. things like alcohol, tobacco, firearms, and petroleum fuels. They are taxes on licenses to pursue certain occupations, again, selling alcohol, tobacco, firearms, etc., and on the corporate privilege, where it is the privilege that is the subject of the excise tax, not the mere handling or earning of money. So again, we see that you have to have the impost, duty, or excise applicable to the earning sources, the activities and transactions conducted, before any taxable income can be derived. Without impost, duty, or excise taxable activity, there isn't any tax to measure with income or by profit. Okay, so they point out, okay, let's keep going here. Without expressly stating all the other contentions, we summarize them to a degree adequate to enable us to typify and dispose of all of them. 1. The statute levies one tax called the normal tax on all incomes of individuals up to $20,000, and from that amount up, by gradations, a progressively increasing tax called an additional tax is imposed. No tax, however, is levied upon incomes of unmarried individuals amounting to $3,000 or less, nor upon incomes of married persons amounting to $4,000 or less. The progressive tax and the exempted amounts, it is said, are based on wealth alone, and the tax is therefore repugnant to the Due Process Clause of the Fifth Amendment. And again, I've laid out they disposed of that because it's an indirect tax and they're allowed to have geographically uniform brackets applied to the person subject to the tax on impost, duty, or excise activities, not as a direct tax. Okay, 2. The Act provides for collecting the tax at the source. Now, this is key. This is they're laying out the constitutional scheme of taxation implemented by the legislation enacted by Congress, and this is why it is constitutional. Again, the Act provides for collecting the tax at the source. That is, makes it the duty of corporations, etc., to retain and pay the sum of the tax on income due on bonds and mortgages, unless the owner to whom the interest is payable gives a notice that he claims an exemption. This duty cast upon corporations because of the costs to which they are subjected is asserted to be repugnant to due process of law as a taking of their property without compensation. And we recapitulate various contentions as to the discrimination against corporations and against individuals. Okay, now this is key. The Act provides for collecting the tax at the source, makes it the duty of corporations, etc., to retain and pay the sum of the tax. This doesn't say it's a direct tax on the wage earner. This says it's a tax that is indirect because it's collected at the source and then paid by the tax collectors, who are never paying tax out of their own pocket. They're only turning over the tax they have collected by withholding money as tax from payments made to certain persons subject to the withholding. And it's that shifting of the burden from the tax collector's pocket to the pocket of the person from whom the tax is collected and withheld that makes it indirect, because the collector, the party made liable for the payment of the tax, isn't paying tax on their own income. They're turning over what has been collected by withholding from others who all turn out to be foreign persons under this 1913 legislation. This creates the withholding agent under 7701A16, who is given the authority to collect the income tax by withholding money as tax from payments made to certain persons. The definition of the withholding agent is in law at 7701A16. It says any person required to deduct and withhold any tax under sections 1441, 1442, 1443, and 1461. That's what a withholding agent is. Any person required to deduct and collect. And those sections, 1441 requires, authorizes, and allows the withholding agent to collect tax by withholding from non-resident aliens. 1442 allows them to collect from foreign corporations. 1443 makes them lawfully able to collect tax from foreign tax-exempt organizations at a slightly lower rate. And 1461 makes the collector, the withholding agent, liable for the taxes collected from foreign persons. And this is the scheme of taxation that was tested and declared to be constitutional. So where is the tax collected from citizens? From 1913 to 1945. Because in 1945, they used the exact same scheme of indirect collection of the source. They just made it apply to the employment relationship where the employer is able to collect from citizens, not because he's required to, but because the citizen, as an employee, asks the employer to withhold the money, not understanding that he's not subject to the tax because it's not a direct tax on his earnings. It's an indirect tax on the earnings of foreign persons imposed by a tariff act. The original legislation was the Underwood-Simmons Tariff Act of October 3rd, 1913, where a tariff is one form of an impost, which is the authority to tax foreign activity, foreign persons, foreign imports, and in foreign places, like the territories and possessions, which is exactly what we see in the 1939 statutes at law. 26 years later, after the income tax, this is all published clearly in Section 4 of the statutes at large, the 1939 statutes at large. Section 4 is the special classes subject to the income tax, and it shows the classes of non-resident aliens, foreign corporations, persons in the possessions, and persons earning most or large sources, a large percentage of the earnings from within the possessions. It's a foreign tax. It's a tariff. It's collected at the source and paid by the tax collectors. And these are all the bases upon which the Supreme Court said it's all perfectly constitutional. They never said it was constitutional as a direct tax, and we know that now because in Moore at Uxt 1 year ago, the Supreme Court says income taxes are indirect taxes under authority of Article 1, Section 8, Clause 1, and the only authority under 181 is impost, duty, or excise. The 16th Amendment created no new powers to tax. It created no new subjects to federal taxation because previous to the 16th Amendment, citizens weren't subjects of any impost, duty, or excise. They weren't the subject of any federal tax unless they engaged in a specific activity, transaction, event, or in a place subject to the power and authority to tax foreign activity, imports and exports, commodities, licenses, and corporations. There was no federal basis to tax individuals' labor or earnings in the 50 states. Didn't exist. All of these discussions that are occurring in a vacuum of that authority. It's all about taxing corporations and licensed persons and foreign persons with geographical uniformity, which allows tax brackets to be applied to those persons and the inanimate commodities and articles of commerce subject to the federal taxing powers. Okay, so it's all constitutional because it's indirect. Okay, I think I hear the second commercial break coming up. This is Thomas Freed on the Liberty Works Radio Network. When we come back, we'll go through some of the specific rulings of the court in the opinion that support what I'm telling you and reading from the opinion here. We're going to look at the specific pieces. We'll be back in 5 with more. Okay, this is Thomas Freed on the Liberty Works Radio Network, and let's get right back into this. As I said, I'm going to go ahead and read a little bit from the actual decisional part of the opinion, so that I'm not reading the entire opinion because it's too long, but picking out the important parts, and anyone who wants to go and verify that this is what it says is, of course, perfectly free to go and Google Bruce Haber and read the opinion. Okay, so let's just get right into this. I'm going to read the short quotes and then talk about it as need be. It clearly results that the proposition and the contentions under it, that is, a direct tax without apportionment. This was the contention of the U.S. government in the amicus curiae brief, that it's a direct tax. It clearly results that the proposition and the contentions under it, if acceded to, would cause one provision of the Constitution to destroy another. That is, they would result in bringing the provisions of the amendment exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes be apportioned. This result would create radical and destructive changes in our constitutional system and multiply confusion. So here the court is rejecting the argued contention in the amicus curiae brief by the government that it's a direct tax without limitation under the 16th Amendment. They're saying you can't use the 16th Amendment to create a direct tax that isn't apportioned as still required under Article 1, Section 2, Clause 3, apportioned to the states for payment, the several states rather than any individual person, and wasn't laid in proportion to the census. The 16th Amendment cannot defeat those limitations imposed on direct taxation. And there's no need for it to do, and it doesn't because it's not a direct tax. It's an indirect tax that isn't subject to those limitations that only apply to direct taxes. The limitation applicable to the income taxes and indirect taxes, that of geographical uniformity. The limitation imposed on all taxes under Article 1, Section 8, Clause 1, as an impost on foreign activity, a duty on exported goods, or an excise on commodities, licenses, and corporations, none of which indirect taxing powers tax the labor of the American people in the 50 states. That doesn't exist. There is no authority granted to tax the labor of the American people in the 50 states. The Constitution still doesn't allow that. That was all done through the perverse and subversive application of the income tax as a direct tax without apportionment, which is what the circuit courts and the lower courts have been doing formally under circuit court precedents, declaring the tax to be a direct tax since 1980, 45 years. The courts have engineered a judicial constitutional rebellion consisting of sedition. They've undermined the proper application of the tax as an indirect tax that doesn't apply to labor, rather than the direct tax without any limitations at all that they've been unconstitutionally enforcing for 50 years, actually since World War II. Let's look. Okay, the court goes on. It is clear on the face of this text that it does not purport to confer power to levy income taxes in a generic sense, an authority already possessed and never questioned, or to limit and distinguish between one kind of income taxes and another, but that the whole purpose of the amendment was to relieve all income taxes when imposed from apportionment from a consideration of the source when the income was derived. So what they're saying is the 16th Amendment doesn't create any exception to direct taxation. It was simply to get rid of the ruling that occurred in Pollock v. Farmers Loan and Trust, where the court held that because of the source taxed, the tax on rent was deemed to be direct rather than indirect. And because of the source argument, the tax was rejected as a direct tax. And the 16th Amendment says the courts can't use a source argument anymore to declare an indirect tax as a direct tax. But the indirect tax is still limited to the imposed duty or excise. It's not expanded by the allowance to tax income. Okay, it goes on. The various propositions are so intermingled as to cause it to be difficult to classify them, the objections to the tax. We are of opinion, however, that the confusion is not inherent, but rather arises from the conclusion that the 16th Amendment provides for a hitherto unknown power of taxation. That is, a power to levy an income tax, which, although direct, should not be subject to the regulation of apportionment applicable to all other direct taxes. And the far-reaching effect of this erroneous assumption will be made clear by generalizing the many contentions advanced in argument to support it. Okay, they're saying it's an erroneous assumption to believe the 16th Amendment created a direct taxing power. And when you recognize that it's not direct but indirect, then all the things alleged to be unconstitutional, because it was direct, allegedly, they all go away. Because it's not direct, it's indirect. It has an entirely different limitation that applies, which is geographical uniformity, which is in place. So there's nothing unconstitutional about the tax enacted under the authorities it was enacted under as a tariff. An indirect tax, not a direct tax. The court goes on. I already read that one, didn't I? It clearly results that the proposition and the contentions under it, if acceded to, would cause one provision of the Constitution to destroy another. That is, they would result in bringing the provisions of the amendment exempting a direct tax from apportionment into irreconcilable conflict with the general requirement that all direct taxes be apportioned. This result would create radical and destructive changes in our constitutional system and multiply confusion. But they just got done saying the point of the amendment would be to simplify and clarify things. And then they say if we adopt this bad argument, it would create confusion. Okay, I think I need to turn the page. Okay, yeah, that's the problem. Okay, now this is from the very next case after Brushaber, Stanton v. Baltic Mining, which was also a case about the income tax. They took two cases in a row in 1913, and they were issued, the orders, the opinions were issued, the decisions were issued consecutively, one right after the other. So this is the next case in the Supreme Court recorder right after Brushaber, and it too addresses income tax. And in summary, the court writes, and Brushaber is really easy to read. It's a short case. If you're checking on Brushaber, you should go on and read this case, Stanton v. Baltic Mining. The provisions of the 16th Amendment conferred no new power of taxation, but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged. So in Stanton v. Baltic Mining, they confirm what they just held in Brushaber, that the tax is indirect and not direct. Okay, now I read the part where the court recites that the Act provides for collecting the tax at the source, that is, makes it the duty of corporations, etc., to retain and pay the sum of the tax, which is where they get the indirect implementation, the indirect scheme of taxation adopted in the tariff legislation. It's collection of the tax at the source and payment by the collectors. It's not a direct tax on the laborer. Not even the non-resident alien is made liable for the tax. They go on. The 16th Amendment, although referred to in argument, has no real bearing and may be put out of view As pointed out in recent decisions, it does not extend the taxing power to new or accepted subjects, but merely removes all occasion which otherwise might exist for an apportionment among the states of taxes laid on income, whether it be derived from one source or another. This is from Brushaber. Again, as repeatedly held, this did not extend the taxing power to new subjects, but merely removed the necessity which otherwise might for an apportionment among the states laid on income, which otherwise might exist for an apportionment among the states of taxes laid on income. Thus, from every point of view, we are brought irresistibly to the conclusion that neither under the 16th Amendment nor otherwise has Congress power to tax without apportionment a true stock dividend made lawfully and in good faith, or the accumulated profits behind it as income of the stockholder. This is from Eisner v. Macomber. It was a slightly different application of the tax, but they state neither under the 16th Amendment or otherwise has Congress the power to tax basically directly and without apportionment. Okay. And they finish up in Brushaber with this. Moreover, in addition, the conclusion reached in the Pollock case did not in any degree involve holding that income taxes, generically and necessarily, came within the class of direct taxes on property, but on the contrary, recognized the fact that taxation on income was in its nature an excise, entitled to be enforced as such, unless and until it was concluded that to enforce it would amount to accomplishing the result which the requirement as to apportionment of direct taxation was adopted to prevent, in which case the duty would arise to disregard form and consider substance alone, and hence subject the tax to the regulation as to apportionment, which otherwise as an excise would not apply to it. Now, what the court is saying there is it's an indirect tax and it should be enforced as such, but if it ever ends up getting enforced as a direct tax, that would be unconstitutional, and then the limitations of applying to direct taxation would prevent it from being applied in that manner, which is, of course, exactly where we're at today, because of the circuit court's reversal, seditious reversal collectively, of this Brushaber decision, declaring the tax is constitutional not because it's a direct tax relieved of all limitations, as the government has been arguing and the courts have been ruling for 50 years, but because it's an indirect tax under Article 1, Section 8, Clause 1, and that constitutional fact means every single income tax case, civil and criminal, for the last 55 years has been a constitutional fraud, wherever the tax alleged owed wasn't derived from impost, duty, or excise taxable activities, i.e. foreign, import-export, commodities, licenses, and corporations. There is no direct tax on the labor of the American people that is made subject to the tax because of sources of gross income. Sources of gross income are not a valid basis for indirect taxation under impost, duty, or excise under Article 1, Section 8, Clause 1. Sources of gross income can only be the alleged basis if it's a direct tax on all earnings, which it's not. When the direct taxation basis goes away under the 16th Amendment, so too does its application to citizens, simply because they have sources of earnings deemed gross income under Section 61. It's all a constitutional fraud. The only earnings subject to the tax are those subject to the authorities to tax by impost, foreign, duty, exports, and excise, commodities, licenses, and corporations. It's all been a fraud, and Moore exposes it all. Okay, I think I hear the end of the show coming up. This is Thomas Freed on the LibertyWorksRadioNetwork.com. Spread the news, spread the word. This information is posted on the Thomas Freed YouTube channel. You can link to it right off of taxfreedom.com. Get reading, get educated.